Maybe just to start, Ms. Kemper, one of the points you raised was this idea of the potential that this legislation, if and when it's passed, will be JOR'd and may end up in the European Court of Justice. And I think that's significant, that you might just flesh that out a bit, because I suppose one of the things that have come to us is the need for certainty about what's happening in Dublin Airport. My colleague Eamon Ryan, when he was Minister, he was always clear, this is a planning condition, and the only way you change that is through a planning application, and there's a planning application in. This very unusual legislation is coming through to try and change the cap. But is it, I suppose, I'd like to flesh out that possibility that after all this, we might end up with a JOR, with a decision going to Europe, and there could be a lack of certainty for another 2 or 3 years. Because could you maybe just explain a little bit about what you would see the basis of a potential JOR on this legislation, potential challenge to this legislation in the Irish courts, and then how it might end up in the European courts?
Well, I think that the main 2 challenges are going to be along the basis of this legislation allows the DAA, a state body, to circumvent environmental legislation regarding unauthorised development and the assessment of unlawful development. I think it will most certainly be challenged on that basis, because the whole point of Derry Bryan was that the government was supposed to bring in domestic laws to prevent that. They did so under Section 3412 of the Planning and Development Act and through a substitute consent regime. One disallows planning applications being granted under Section 3412 if they have unauthorised development, and it sort of forces them into the substitute consent regime. That was as a result of a court case, and the EU told us we had to do that. The other issue is that every country in the European Union has to do this. Every other airport in the EU are subject to the same laws. And have their same individual provisions to prevent this from happening. So it's a very serious issue, and I can't see that the CJEU would go, do you know what, a state body, the government can, give their own state body a get-out-of-jail-free card, and we're going to be okay with that. It's not something...
Sorry to cut across you. Derry Bryan was litigated for a very long time, is my recollection, across both the Irish and the European courts. Correct. So I suppose there's a strong... not quite precedent, but there's a strong and recent case law directly applicable to Ireland about this idea of kind of ignoring breaches of planning law.
Yeah, so, and I think, and I've let my colleagues speak about the climate litigation and the emissions end of things, but it's a very serious issue as well. And I think that there is no doubt in my mind that it won't be just one NGO taking a JOR. I'd say you'll probably find nearly everyone who's sitting at this desk would be as well, because it's so important, not just to us here domestically in Ireland, but across the EU, in the EU context. It's going to have an impact on every sectorial area. And we've seen the recent issues around with the fuel protests. I mean, essentially giving airlines and the DAA the okay to breach the law on emissions and not properly assess them on environmental assessments, and then pushing those obligations onto other sectorial areas like farming, like transport. It's just simply unfair. And on individual people, the taxpayer, you have to start cycling more, you have to do this more because, we have to meet our objectives. And yet there's a whole area that is being basically excluded by this bill, by Head 12 of this bill. It just is wrong, and I can see that would get past the gatekeepers of the CJEU, but perhaps somebody else might want to speak to that.
I might just, if I could bring Mr. McVilly in, because I suppose we spoke about a similar provision in the Strategic Gas Reserve Bill at the Climate Committee a couple of months ago. I think at the time I asked, were you worried that provision, excluding Section 15 of the Climate Act, would be kind of the start of a process? And since then we've seen similar provision in this bill, and then last night we were discussing the Strategic Infrastructure Bill at second stage in the Oireachtas, which proposes to exclude the climate duty under Section 15 for a whole range of projects that will be designated as strategic infrastructure. So you might just speak about that, this, I suppose now, quite clear approach been taken across government to exclude consideration of climate considerations under a bill that was only passed 5 years ago. But secondly, you raised a point about how positive climate steps taken, maybe in this case by Dublin Airport, actually are given the degree of protection under Section 12. Because my reading of the Cool Glass case is that planning permission was the attempt to build the wind farm was actually protected by Section 15. And my concern is where you have big projects, big transport projects like a new Lewis or something, it actually gets protection under Section 15 because the body, the NTA or Transport Infrastructure Ireland, are advancing it to fulfil their climate duty, their climate obligation. And if they're excluded, they're gone. That protection doesn't exist anymore. So you might just speak to that point.
Thank you very much, Deputy. Yeah, so 3 different points. I guess, first of all, to state the political facts, it is usually concerning where parties who were involved in the last government, who very clearly supported the need for robust climate governance legislation, only a short period later are actively seeking to disapply substantive elements for it, and substantive elements where there isn't, in our view, sufficient justification, as has been mentioned. And actually, just to extrapolate on that a little bit more, to be clear, in the general scheme, there is not an explanation as to why that section is being disapplied, which in our view is simply unacceptable. And to take up your point that there are now 3 different bills which are fundamentally weakening climate law, to be clear, what's present or proposed rather in the general scheme of the Strategic Emergency Gas Reserve Bill is a little bit different in the sense that it is giving the Minister particular powers. It is giving the Minister essentially power to deem that this legislation, or rather that the project that the legislation relates to, is in compliance, whereas this proposed bill and the critical infrastructure bill is about disapplying a certain provision. But ultimately, the upshot is an attempt to undermine, and in light of the cool glass judgment that you mentioned, undermine or weaken the obligation on relevant state bodies. And the key issue here is that, in our view, this only increases legal risk. That you're essentially, while the government may take a view that it is potentially expediting the process by preempting the possibility of judicial review, as a number of us here have outlined, the way the government is proposing to go about removing the passenger gap rather increases the likelihood, including related to climate law, but increases the likelihood of judicial review, of legal challenge, which would ultimately delay the type of development that the government seems to want. The last point I wanted to make was just
protective element of Section 15.
Yeah, exactly. And I think it's a really crucial point, because it's not clear to me that the officials, the DAA, the IAA, have perhaps interrogated this issue in depth, that the climate law is not simply a restrictive measure. It is not simply there to introduce constraints. It can actually be put in place to ensure that development is done in a way that reduces emissions, but also supports broader well-being. Of course, and sustainable development of the area. For example, public transport around the airport. So the basic point is, where this framework provided by Section 15 of the climate law is disapplied, it could undermine perhaps progressive policies that the aviation sector, or at least DAA, may want itself. And as you said, there is also the risk that where other individuals may take a case against development at Dublin Airport on particular grounds, the state, one would expect, would actually want climate law in place to ensure it can be facilitated in a sustainable manner.
Thank you. Thanks for that. When we debated the critical infrastructure bill last night, one of the reasons why Minister Chambers argued that the provision in that bill to Section 7 to exclude Section 15 of the Climate Act was because of judicial reviews. That was very much with his focus. Could I get a sense, are there a lot of judicial reviews in the system right now on the basis of Section 15 of the Climate Act? Is like many of you would be linked in that area. Do you know? I suppose you could refer to the challenge to the Galway Ring Road, but that was basically because An Bord Pleanála just hadn't done their job. They hadn't actually done any analysis under Section 15. So are you aware of any judicial reviews in place right now on major projects where Section 15 is kind of the linchpin? Because I'm not, and Minister Chambers wasn't able to cite any to me, but I'm just wondering.
I'm not aware of any actually at the moment, but I know it has become a new potential ground for judicial review if it's not adhered to. I think one of the big issues around this kind of death by 1,000 cuts approach on legislation is that it makes it impossible to do cumulative impact assessments under the EIA, AA and Water Framework Directives. It immediately impacts strategic environmental assessment SEAs that are required on certain policies and programmes as well. If you start excluding this critical infrastructure, that critical infrastructure, the airport, suddenly you can't carry out a proper SEA on anything when you're coming to policies. You can't carry out proper environmental assessments, appropriate assessments on developments that may interact with those developments. In terms of the climate aspects of EIA assessments. So it's very, very messy, and effectively what the government are doing is they're just clouding the waters, and they're making it easier to judicial review because of those cloudy waters, because it's not clear, precise, and in effect what they're trying to do is avoid judicial reviews. I think it's actually going to lead to even more. And that is the difficulty. And
like the strategic, how the STZ?
Strategic environmental assessments are assessments that have to be done on government policies, on things like county development plans. If you were doing sort of your DMAPs for the coastal areas, strategic environmental assessment has to be carried out on all of those, and it's supposed to feed in any major developments within that policy or area.
Ms. Desmond?
Yeah, no, fine. Yeah, we're fine for time. Yeah.
I think the comments you just mentioned there from Deputy Chambers and the overall narrative in this bill and other bills, it shows a focus on preventing what might be very bad decisions from being challenged. And we would say what's really important when legislating is to set up the circumstances that allow good decisions to be made in the first place. And rather than focusing on things like, well, we don't want to have to deal with Section 15 because we might get it wrong, so then we might be challenged, it should be setting up the circumstances to make sure decisions are made that actually comply with our Climate Act and comply with our law. And the very basic elements of that are that all of the information that's relevant is actually before a decision maker such as the Minister, and that is not helped by Head 12 of this bill, and making sure there is accountability and scrutiny so that decisions have to be out in the open and have to be held up to be robust, which is not helped by having very limited appeal mechanisms and limited mechanisms for the public to hold the government to account on those decisions.
Thanks. Mr. McMillan, did you want to?
Yeah, I'm not aware of pending JR under Section 15 explicitly, but just to see, and again to echo what's just been said, the point of Section 15 is to ensure that developments comply with the Climate Act. So the way to avoid judicial review is to ensure that developments comply with the Climate Act. But more generally, and I don't know whether this is a conscious thing in the background or not, but if the Climate Act were being applied more generally in a coherent and systematic way, then the Climate Action Plan would be providing the big picture story into which things like strategic infrastructure were already factored. So that when the EPA presents their projections of emissions against carbon budgets, taking account of the strategic infrastructure plans that are in the pipeline, then they would show that we're going to comply with our carbon budgets. So the real reason why there's this, concern, or a potential real reason why there's a concern about vulnerability under Section 15 goes back to the fact that successive governments, but this government in particular, have either just not brought forward a climate action plan in a timely way, and that's just in the cloud somewhere at the moment, or the climate action plan that they bring forward, when assessed, is nowhere next or near meeting the requirements of the carbon budget framework. And it just follows, as day follows night, that any development, virtually any development, is then vulnerable because it's going to contribute to that overshoot. So the right thing here is not to subvert the Climate Act, but to actually implement it.
Chair, would you indulge me with just one final question?
1 minute.
Yeah, thanks very much. Ms. Tunney, you said in your statement that the lifting of the passenger cap will increase emissions when the airline representatives were in here a couple of weeks ago. I put that point to Willie Walsh that going from 32 million to 40 million would definitely increase emissions. And he came back at me really hard, no, it will not, because of sustainable aviation fuel, because of improvements on engines. He was so adamant, I was actually a bit taken aback by it. But like, could you speak to that? Because when I reflected later, I was like, I'd like to hear your views on 8 million extra passengers not increasing our emissions.
Yeah.
Just briefly.
Yeah, very briefly. I haven't seen any evidence to support Willie's statement. We know for a fact that where we're at the moment, if aviation growth keeps going, we're going to be hitting 4 Celsius heating rather than the 1.5 if they keep going, and we are supposed to reduce emissions now. Like, if we're going to hit any 1.5 target from aviation, we need to reduce flight numbers now. Like, there has been some gains from technology and efficiency, but nothing to deal with the growth that is going in every airport. And again, we spoke a lot about SAF. The numbers aren't there, and we feel that it is a distraction. There are many tools to this, to dealing with aviation emissions. Demand management is definitely one of them. Growth is definitely one of them. And in the future, potentially ESAF. But at the moment, between where we are now and when we get to ESAF, which is 10, 20 years, we really need to be looking at taxation and demand management. I don't know if you want to very quickly, sorry.
I'll just add, I guess, 2 quick things. One is there is no mitigation measures for international flights. Just keep on bringing that home. There are some for intra-EU, but basically none for international. So how he is suggesting that they might not increase emissions is a mystery. And the other thing I would say is he might sit here and say that, and, oh, don't worry, we're going to have all the staff or whatever. Well, I guess he's just changed jobs, actually, so I can no longer say this, but organisations that he was previously members of are lobbying really, really hard at the EU level to not only ensure that the emissions trading system on international aviation does not appear in legislation or in proposed legislation this July, but also to roll back the legislation that already exists in the EU. And they have also been incredibly strong every time any national government tries to take anything. So the Irish tax that we had on passengers before was essentially lobbied against by a number of airlines, and that's why it was removed. And there's a whole history of it. And I have been working on aviation since 2012 and have seen a lot of it. And, you know, I would just say, I guess, one thing for the committee as they go forward with their report is, at the end of the day, to at least be honest with the Irish people and to see through that airline just lobbying, at least to say that this decision is going to have serious kind of consequences. And we can then at least, you know, take it from there.
Okay. So just very briefly.
If you mind, just on section 15, I think one thing that comes out from the Kublas judgment is this sense that only in marginal cases will section 15 actually be relevant to an individual planning decision. In general, as Professor McMullen outlined, if you have a broader framework, policy framework, the Supreme Court noted climate is considered as part of that broader framework, so it doesn't arise in individual cases. And the situation here is that the broader framework in aviation has gaps. But at the same time, Section 15, as interpreted by the Supreme Court, is simply a sense check on decisions. It doesn't dictate any one outcome, and it is simply having a more balanced approach that considers climate as part of the overall process.
Okay. Thank you. Do you want to come back in again? No.